And now talking about the Supreme vindication for Victoria Gowri. She's been sworn in as a judge, as the additional judge in the Madras High Court. And this certainly has come out as a big setback to all those who were contesting her elevation. Remember, there were 21 lawyers in total who'd in fact petitioned against her appointment. The top court agreed to listen to them. The top court admitted their pleas. But today, the Supreme Court bench has said that having past political affiliations does not come in the way of delivering justice. We quickly first up show you the moment wherein Advocate Victoria Gowri took oath as the additional judge of the Madras High Court. Take a look.
I, Lakshmana Chandra Victoria Gowri,
having been appointed as additional judge of the High Court of Madras,
having been appointed as additional judge of the High Court of Madras,
do swear in the name of God
do swear in the name of God
that I will bear true faith and allegiance to the Constitution of India as by law established,
that I will bear true faith and allegiance to the Constitution of India as by law established,
that I will uphold the sovereignty and integrity of India,
that I will uphold the sovereignty and integrity of India,
that I will duly and faithfully and to the best of my ability, knowledge and judgment,
that I will duly and faithfully and to the best of my ability, knowledge and judgment
perform the duties of my office without fear or favor,
perform the duties of my office without fear or favor,
affection or ill will,
and that
I will uphold the Constitution and the laws.
As she took oath in Chennai, in Delhi, the top court junked the petitions opposing her elevation, stating that people with political affiliations have been appointed as judges in the past as well, and that in each of those cases, political affiliations have never come in the way. In fact, the bench also began by admitting that there's a difference between eligibility and suitability, and that the courts should not get into suitability. It's the Collegium that takes these things into account. However, some in the opposition refused to abide by the Supreme Court's wisdom. Several protests were held against her elevation even after she was sworn in. Listen into some of the reactions coming in after she was vindicated.
Somebody has an opinion which you don't like. How can you say that it will affect her quality as a judge? I mean, she is not going to be alone. She's going to be part of, in any matters where Islam and Christianity, it'll never be a single judge matter. It'll be 2 judges or 3 judges. So how do we know that she is going to do this? I don't think. I fully support the Supreme Court stand, and I fully support the Government of India stand in appointing her as judge.
Supreme Court Collegium appointed or RSS spokesperson Victoria Gowri as a judge for Madras High Court. CPM strongly condemned the Supreme Court Collegium recommendation. Is now at same law ministry, same Supreme Court, same central government. How can they appointment RSS spokesperson as a judge of Madras High Court? So we strongly condemn the Supreme Court Collegium. Don't appoint RSS spokesperson as a judge for Chennai High Court.
Victoria Gowri கிறிஸ்தவர்களையும் முஸ்லீம்களையும் மிக மோசமான முறையில் சொல்லக்கூடாத வார்த்தைகளால் விமர்சனம் செய்த ஒரு நபர் நீதிபதியாக வருவதற்கு தகுதியற்றவர். அவர் இப்படி நியமிக்கப்பட்டிருப்பது பெரும் அதிர்ச்சியை தருகிறது. மறுபரிசீலனை செய்ய வேண்டும் என்று நேற்றே நாங்கள் அந்த அறிவிப்பு வந்தவுடனே ஒரு கடிதமும் நாங்கள் அனுப்பியிருக்கிறோம்.
Interestingly, one of the Supreme Court judges who was part of the bench today, Justice B.R. Gowri, himself alluded to his political past before taking oath as a judge. Let's remind you now how in the past having a political affiliation has had no consequence in delivering justice. So let's quickly talk about these several instances that we're now focusing upon, especially with regards to judges in our country. We're talking about Justice B.R. Gowri, who himself cited his own example while coming out with this relief for Victoria Gowri. He says his father and brother founded the party RPR Gawai. That's a stated fact. And despite having had a political affiliation in 2003, he was appointed as the Bombay High Court judge, and quickly thereafter he was appointed as another judge in the Supreme Court. So right now he's a top court judge, and in 2003 he was appointed as the High Court judge as well. And despite his political affiliations in the past, this is a stated fact which he himself cited while passing the order in this very case. We move on to Justice Barul Islam. He was a two-term Congress Rajya Sabha MP from 1962 to 72, 1962 to 1972. So good 10 years. He had clear political affiliations. Regardless of that, once again telling you about his career and his legal experience. He, remember, gave a verdict in the Bihar bank scam case. In 1972, he resigned as a MP and he was made a top court judge. So he was made a Supreme Court judge, clearly indicative of once again how he'd gone ahead with several rulings. He'd taken up several cases and was a judge in the top court of our country. So that's a second example that we put out. We move on to Justice Ratnavel Pandian, who was DMK's Tirunelveli District Secretary. So there was an association with the DMK, the southern party in our country, which is currently in power in Tamil Nadu as well. And despite that, in 1974, he became a judge of the Madras High Court. So this is a third stated example. The fourth one, of course, being of Justice Krishna Iyer. From 1957 to 59, he was a minister in CPI Kerala government. And despite that, in 1968, he became a judge at the Kerala High Court. So there are several instances of these judges at the High Court level who have been a part of the top court bench as well, and have had no interference with regards to all of those cases that they've taken up through the course of their legal experience. With that, we quickly open this up. Namit Saxena, advocate, joining us along with CK Kumaravel, who is also a political analyst. But let me quickly begin by asking Mr. Namit Saxena this, as to why do you think there is this clear opposition that is coming in, protests that refuse to die down, despite the top court having to make it very, very clear that despite these kind of political affiliations in the past, they have never ever come in the way of judgments of their work, of their career. And I've just put out 4 such examples, Mr. Saxena.
The Supreme Court is right in, dismissing these writ petitions and saying that past political affiliations that, when you were a lawyer, cannot affect your credibility or your merit as a judge who will be deciding cases as a presiding officer of Constitutional Court. Second, what the Supreme Court has very rightly pointed out is this, that eligibility and suitability are 2 different things. If the case would have been of eligibility, that a particular candidate is not eligible to become a judge of a constitutional court, for example, in this case of the High Court, that can be challenged in a writ petition, and the Supreme Court can issue perhaps a writ or a notice to the Collegium of the Supreme Court on the administrative side and ask that as to why an eligible candidate has been chosen or recommended to become a judge of the Constitutional Court. But in case of suitability, see, Collegium is a dedicated body which decides on suitability of a particular lawyer to become a judge. Now, on suitability, the Supreme Court can't issue a writ to itself through the Collegium and say that on the administrative side, the Supreme Court has taken a wrong decision and show cause as to why, why did you recommend this particular candidate is very, very important. That is why they said that we can't look at, suitability. Eligibility, perhaps there is a 1992 precedent where eligibility they actually looked at. There was this Mr. K. N. Srivastav. They said, he's not eligible. We can't appoint him, even though he was recommended. And that, if you remember, that time the Collegium had just, begun in 1991 after the 1990, the judgment in the second judge's case.
Yes.
So, the Supreme Court is right in saying that eligibility, that suitability, we can't look at. So past political affiliations, and there are so many examples.
And despite that, Mr. Saxena, it's not like the Supreme Court did not take up the issue. It's not like it did not hear the matter.
Yes.
While the oath-taking ceremony was underway, the top court proceedings were also on. Mr. Kumaravel, then why this kind of an opposition despite the top court's intervention, despite the top court junking all of those petitions? Remember, 21 lawyers have opposed to this particular elevation, but the fact remains that there is a proper background check that goes into each and every advocate while they are in their race to make it to the High Court, the Supreme Court. So why this kind of an opposition? Do we not trust our courts? It is the Collegium that had proposed these names.
Yeah, one is it is important to be fair. It is also important to appear fair. In this case, how the Supreme Court looks at it may be fair, but is it appearing fair in the eyes of everybody? That's the big question. Why the Advocate John Sathyan appointment of the judge of the Madras High Court has been pending since February 16, 2022, almost a year, while the appointment of Victoria Gowri's appointment is cleared in less than a month. This sends a very wrong message. John Sathyan has liked some of the remarks in a Facebook post or a Twitter post which is against Modi, and there is no anything against John Sathyan otherwise. If that is the case, for why his appointment has been pending for a year, and then in that same light, you have to look at the Victoria's appointment, which has been cleared in 1 month. That's what is bringing us one point. The second point, which is even more important, is that appointment of a judge with a history of hate speech. That is what is, and she has called the Christians as the white terrorists and the Muslims as the green terrorists.
But to put that in perspective, and we must specify that as well, Mr. Kumaravel, all of those alleged hate speeches, all of those articles that have been cited by everybody today who's opposing her elevation, remember, is with regards to religious conversions, religious conversions, and that's been specifically mentioned as well in all of those speeches and all of those articles. So the context here is also important. We must put that out.
Yeah, context may be there, but if somebody has that kind of mindset, there is a way to express, and if that person is given the highest post, how is she going to handle a similar situation as a judge? That's something which needs to be looked into.
Mr. Saxena, how would you respond to that?
See, a writ or any order or direction in nature of a writ cannot be issued on presumption and assumption. See, this is just an assumption that tomorrow, if this candidate becomes a judge, as a judge, this particular individual will have certain, political affiliations or certain views or certain thought process as to, a particular topic. So this is just an assumption. And there are so many examples we have seen. See, as you pointed out, Justice Krishna Iyer was a communist government's minister. Even then, he was made a High Court judge. And I'll tell you something as a matter of fact, that immediately after 2 years of being a High Court judge, he was elevated to the Supreme Court also. So, so these factors, may not weigh at all. So on presumptions that this particular candidate may do something when he or she becomes a judge is completely, baseless.
Okay.
A writ cannot be issued.
Mr. Saxena, correct me if I'm wrong, but the top court, while junking all of those petitions, also laid emphasis on the fact that they're not going to rule out the possibility, and that's a stated norm, that anybody not living up to their duties can be denied, being turned into a permanent High Court judge. So in that sense, that's always an option that lies before the petitioners.
Yes. So what they've done is they have appointed her as an additional judge. So after a year or after 2 years, her performance is to be evaluated, and thereafter she is to be made a permanent judge or not is something which is to be again looked at. If her performance is not good, or the judgments which she delivers, or the orders she passes, or public speeches she gives as a judge of the High Court, if they reflect that this particular candidate still carries on certain notions, then these will definitely weigh into giving him permanency as a High Court judge. All these factors are to be looked at. But the Supreme Court also today interestingly pointed out that all this material which you're pointing out today, we can't presume that the Collegium was not aware of these materials. Okay. Because the recommendation came from the High Court, the Chief Justice of the High Court and 2 judges of the High Court, top 2 judges. So they can't be overlooked that these material, whatever, because these are 2018 speeches, that 2018 lectures, etc. It can't be presumed that this material was not before the Collegium. So on basis of assumptions by, for few people, petitioning the Supreme Court and invoking the Constitution directly, it can't assume that this material was not there at all.
Okay.
So the
Mr. Kumaravel, we should then trust our courts, because it's not as though in the past the courts have not intervened at this particular junction whatsoever. And I may go ahead by citing this example. In 1992, the top court had passed an interim order restraining the appointee from taking oath and assuming office as a judge. And I'm talking about the appointment of K.N. Srivastav as a judge of the Guwahati High Court. So it's not as though this has not been done in the past. And now that the top court has made some observations, it's gone out to say in as many words that anybody's political affiliation is not going to come in their way. So far has not, and it's not going to be witnessed in the future. Why don't we just trust the courts?
Yeah, we can definitely trust the court. That's exactly is the point. But only my request is, if John Sathyan case is also looked at favorably, it will look very nice.
And how do you propose that happen, sir? Because, you know, the contention on the other part may very well be that this is your own perception, that this is your own, perception and how you're gauging into the entire aspect of what she's said in the past. It goes back to 2018, sir, not in 2021 or 2022 for that matter.
No, you have made that point of that is spoken in a particular context. I have moved away from that. I agree to you on that. But my this thing is, if John Sathyan, his appointment which has been pending for a year, okay, if that is also cleared, that makes a completely different scenario. Here now I am presuming that because she is belonging to a BJP, her appointment has been cleared in less than a month.
But Mr. Kumaravel, that's again your perception. How is your perception to be taken as the truth or the reality? Mr. Saxena, how would you respond?
See, we are comparing oranges and apples here. This is not a singular notification or singular recommendation for Justice Victoria only. There were 4 other people who also recommended in the same resolution by the Supreme Court, and they have all been elevated. And see, my learned friend, I don't know why he's pushing for, John Sathyan. I don't know if he's, acting as a spokesperson or what, but these are not proceedings for John Sathyan. See, John Sathyan cannot be pushed just because other people have been appointed as High Court judges today. There are other reasons why John Sathyan was withheld, and the Supreme Court has now, Collegium has now reiterated his name, and the centre is now yet to take a call as to what is to happen to the particular candidate. His candidature cannot be pushed, in form of, because you have made Justice Victoria as a judge of the High Court, now John Sathyan also should be made. This is like comparing oranges and apples and circles and triangles. This is completely baseless.
Okay.
John Sathyan is a different
Mr.
case
Kumaravel,
altogether.
are we mixing the two issues? Are we not taking into consideration what perhaps was said by the 21 dissenting lawyers in the first place, because their contention was that this recommendation to elevate the Advocate Gowri dents the independence of the judiciary. Now you're saying that you're quite okay with that, but the fact that the elevation has taken place in no time is problematic in itself? Mr. Kumaravel. Can you hear me, sir? Mr. Kumaravel? Okay, not quite sure if he's getting my audio. Mr. Namit Saxena, if you would want to answer that, because, the entire contention began with the kind of alleged hate speeches Victoria Gowri had made in the past, how she was previously affiliated with the BJP and so on and so forth. And now, we see a change in the goalpost perhaps, because suddenly the issue has become about how is it that this elevation took place in a month's time?
See, there are 2 very important things. One, that in 2018, because the timing is very crucial. Once only she was recommended by the Supreme Court, not only recommended by the High Court to the Supreme Court's Collegium, recommended by the Supreme Court's Collegium to the central government to, to appoint her as a judge. The timing is very crucial. It is now when, everything is coming up. Now, these lofty terms like hate speech and hate crime, everything has been used in public parlance.
Absolutely. The fact is that it's the Collegium that's taken this decision, and remember, in consultation with the union government, which, remember, conducts a background check with intelligence agencies, and all of that has been done, and then comes the top court's ruling today. Thank you, gentlemen, for joining us on this debate.